Yes, sir.
Attorney Smith, Attorney Brooks, ready?
Yes, sir.
All right, we'll bring the jurors in now. Bring them in. Please rise for the jury.
All rise for the jury.
All right, I'll ask the jurors to please remain standing. Everyone else, you may be seated.
Members of the jury, I'm going to swear you in now, so if you could please raise your right hands, and at the conclusion of the oath, if you would please say, "I will." You so solemnly swear or affirm that you will carefully consider the evidence and the law presented to you in this case, and that you will deliver a fair and true verdict as to the charges or charges against the defendant, so help you God. Amen. Thank you. Members of the jury, you can be seated. I'm going to now read the charges to you in this matter. There's 5 charges. The first is charge ID 193-7947C. This states that Adam Montgomery of Manchester, New Hampshire, of Manchester in the state of New Hampshire, between approximately July 1st and July 22nd, 2019, at Manchester in the county of Hillsborough aforesaid, did commit the crime of second-degree assault, in that Adam Montgomery did knowingly cause bodily injury to H.M., date of birth 6/7/2014, a child under the age of 13, by striking her in the face. Said acts being contrary to the form of the statute, in such case made and provided and against the peace and dignity of the state. The next charge in this matter is charge ID 202-7112C, and this states that Adam Montgomery of Manchester in the state of New Hampshire, on or about December 7th, 2019, at Manchester in the county of Hillsborough aforesaid, did commit the crime of second-degree murder, in that Adam Montgomery did recklessly cause the death of Harmony Montgomery, date of birth 6/7/2014, a person under 13 years of age, under circumstances manifesting an extreme indifference to the value of human life, by repeatedly striking Harmony Montgomery on the head with a closed fist. Said acts being contrary to the form of the statute, in such case made and provided and against the peace and dignity of the state. The next charge is charge ID 202-7113C, and this states that Adam Montgomery of Manchester in the state of New Hampshire, between approximately December 7th, 2019 and March 4th, 2020, at Manchester in the county of Hillsborough aforesaid, did commit the crime of falsifying physical evidence, in that Adam Montgomery, believing that an official proceeding, as defined in RSA 641:1, Roman numeral 2, or an investigation was pending or about to be instituted, did purposely alter, destroy, conceal, or remove the body of Harmony Montgomery with a purpose to impair its verity or availability in such proceeding or investigation. Said acts being contrary to the form of the statute, in such case made and provided and against the peace and dignity of the state. The next charge in this matter is charge ID 202-7114C, and this states that Adam Montgomery of Manchester, New Hampshire, at Manchester, between December 7th, 2019 and March 4th, 2020, did commit the offense of abuse of a corpse, in that the defendant did purposely and unlawfully removed, concealed, or destroyed the corpse of Harmony Montgomery or any part thereof. And this is against the peace and dignity of the state. And then the last charge is charge ID 202-7115C. And this states that Adam Montgomery of Manchester in the state of New Hampshire between approximately December 7th, 2019 and January 4th, 2022, at Manchester in the county of Hillsborough aforesaid, did commit the crime of tampering with witnesses and informants, in that Adam Montgomery, believing that an official proceeding as defined in RSA 641:1, Roman numeral 2, or investigation was pending or about to be instituted, did purposely attempt to induce or otherwise cause Kayla Montgomery to testify or inform falsely. Said acts being contrary to the form of the statute in such case made and provided and against the peace and dignity of the state. Ladies and gentlemen of the jury, the defendant, Adam Montgomery, has been arraigned on these charges and he has pleaded not guilty, and of this he puts himself upon his country for trial, which country you are. Assistant Attorneys General Benjamin Agati and Christopher Knowles for the state have joined the issue, and you are to say by your verdict if the defendant, Adam Montgomery, is guilty of the crimes whereof he stands indicted or not guilty. Hearken to the evidence. Thank you.
Members of the jury, shortly you will hear opening statements by counsel. Before that, I'm going to give you some general instructions as to the law that applies to this case and some other matters which will give you some guidance as you consider the evidence in this case. After you have heard the evidence and you have heard closing arguments, you will hear further instructions from the court, and then you will retire to the jury deliberation room to decide your verdict. You should consider all of the instructions I give you, both now and at the end of the case as a whole, and not single out one particular instruction as stating the law. You will also have written copies of my instructions with you in the jury deliberation room. So, ladies and gentlemen, this is not a memory test. What I ask of you now is just listen carefully to the instructions that I give to you. You will have as many copies as you like in the deliberation room when it comes to decide your verdict. So you will have written copies of both the instructions that I give you now as well as the ones that I give you at the end of the case as a whole. And every juror can have one available to them. So please just listen carefully now as I give you these instructions. The function of the court and the jury. In order to reach a fair and just verdict, you must understand and follow the law as I explain it to you. For example, you have to understand the definitions of the crimes with which the defendant is charged. You have to understand how convinced one way or the other you should be before deciding your verdict. You have to understand what to consider in deciding whether to believe a particular witness. These instructions will explain the law as to these and other matters so that you can reach a fair and just verdict. It is your duty as jurors to follow all of the instructions I am about to give you. Regardless of any opinion you may have as to what the law ought to be, the law as I explain it to you is the law you must follow in reaching your verdict. It is up to you to decide the facts. You must decide the facts solely from the evidence in this trial. You must apply the law given to you in these instructions to the facts and in this way reach a fair and just verdict. You should decide the facts without prejudice, without fear, and without sympathy. You should decide this case based solely on the evidence presented and the law as I explain it to you. The evidence in the case. In deciding this case, you should consider only the evidence in the case. The evidence consists of testimony under oath of the witnesses, exhibits which have been admitted into evidence, facts of which I take judicial notice, and stipulations of certain facts. During the trial, the lawyers may make objections. The lawyers are supposed to object when they believe that certain evidence is not admissible. If I sustain an objection or exclude any evidence, you must not guess as to what the answer or evidence would have been. If I order that a question and answer be stricken from the record, you must not consider either the question or the answer as evidence. A judge is required to be neutral, and I am in fact neutral. If during this trial or at any point during these proceedings you believe that I have expressed or suggested an opinion as to the facts in my rulings, you should ignore that belief. It is up to you alone to decide the facts. In short, you should consider only the legally admissible evidence in deciding this case, that is, the testimony of the witnesses, the exhibits, stipulations, and facts of which I took judicial notice. We talked earlier that there will be a view in this case, and I'll give you an instruction on the view later, but the view is also evidence in the case, but you'll hear an instruction on that in a little bit. The indictments are not evidence. The fact that the defendant has been arrested and indicted is not evidence of guilt. The indictments are simply a way of giving the defendant notice of the charges. The indictments are a formal way of accusing the defendant of a crime in order to bring the defendant to trial. You must not consider the indictments as evidence of guilt. Multiple indictments, one defendant. Each of the indictments against the defendant constitutes a separate offense. You must consider each indictment separately and determine whether the state has proven the defendant's guilt beyond a reasonable doubt. The fact that you may find the defendant guilty or not guilty on one of the indictments should not influence your verdict with respect to the other indictments. The possible punishment the defendant may receive if you return a guilty verdict should not influence your decision. The duty of imposing sentence is solely for the judge. You should base your verdict only on the evidence and the law without considering the possible punishment. The presumption of innocence. As you were instructed during the general selection process, there is a presumption of innocence that applies and continues throughout this trial until the state convinces you, beyond a reasonable doubt, that the defendant is guilty of each and every element of the offenses with which he has been charged. And the defendant has no obligation whatsoever to prove his innocence in this matter, and that includes the right not to testify if he so chooses. You are not allowed to draw any unfavorable, adverse, or negative inference if the defendant does not take the stand in this matter. The jury's recollection controls. You will hear the lawyers discuss the facts and the law in their opening statements and closing arguments to you. These statements and arguments are not evidence. Their purpose is to help you understand the evidence and the law. If the lawyers have stated the law differently from the law as I explain it to you in these instructions, then you must follow these instructions and ignore the statements of the lawyers. If the lawyers state the evidence differently from how you recall it, then you should follow your own memory of what the evidence was. Direct and circumstantial evidence. There are two kinds of evidence, direct and circumstantial. Direct evidence is direct proof of a fact, such as the testimony or statement of a person about what the person saw, heard, or did. Circumstantial evidence is indirect evidence, that is, proof of a chain of facts from which you could find that another fact exists, although it has not been proved directly. For example, if you look outside and see water droplets falling from the sky, that is direct evidence that it's raining. But if you look out the window at night and the ground is dry, and again the next morning and the ground is wet, that is indirect or circumstantial evidence that it rained during the night. By circumstantial evidence, I simply mean that you may infer the ultimate fact from another fact shown. You should feel free to reach reasonable conclusions from proven facts. Conversely, you may not reach conclusions based on facts that have not been proved. In the rain example, wet ground alone may support an inference that it rained during the night. But in the absence of additional evidence, it will not necessarily support inferences about how much rain fell or for how long a period of time. You should consider both kinds of evidence. You are permitted to give equal weight to both, but it is for you to decide how much weight to give any evidence, whether it be direct or circumstantial. However, to be sufficient to establish guilt beyond a reasonable doubt, circumstantial evidence must exclude all other rational conclusions. This means that if from the circumstantial evidence it is rational to arrive at two conclusions, one consistent with guilt and one consistent with innocence, then you must choose the rational conclusion consistent with innocence. In determining whether all rational conclusions other than guilt have been excluded, you should not consider any item of circumstantial evidence in isolation. Rather, you should consider each item of circumstantial evidence in the context of all of the other evidence, which includes all other circumstantial evidence and direct evidence. You must understand, however, that this circumstantial evidence rule does not apply to direct evidence. If there is a conflict between two or more witnesses who offer direct evidence concerning certain facts, you should resolve the conflict. For example, suppose there are two eyewitnesses to a crime, and one testifies that the defendant committed the crime, and the other testifies that the defendant did not commit the crime. This presents a situation where there is a conflict in direct evidence. In this situation, you, the jury, should resolve the conflict and must decide whether, based upon all of the evidence, the state has proved the defendant's guilt beyond a reasonable doubt. You should consider all of the direct and circumstantial evidence in the case, as well as any reasonable inferences you draw therefrom, in deciding whether the state has proved all of the elements of the crime beyond a reasonable doubt. The credibility of witnesses. In deciding this case, you must decide the credibility of witnesses. That is, it is up to you to decide who to believe. If there is any conflict between the witnesses, then you must resolve the conflict. Simply because a witness has taken an oath to tell the truth does not mean that you have to accept the testimony as true. Use your common sense and judgment. Consider factors you use in deciding important issues in your everyday lives. For example, you may consider the following: the witness's attitude, behavior, and appearance on the stand, and the way the witness testifies. The witness's age, intelligence, and experience. The witness's opportunity and ability to see or hear the things about which the witness testifies. The accuracy of the witness's memory. Any motive of the witness not to tell the truth. Any interest that a witness has in the outcome of the case. Any bias of the witness, or friendship or animosity the witness may have for or against any of the other people in the case. The consistency or inconsistency of the witness's testimony. Whether or not what the witness says appears reasonable or unreasonable. Whether what the witness says is consistent or inconsistent with the testimony of other witnesses or with statements the witness made at another time. In deciding which witness to believe and how much of their testimony to believe, you should consider both the direct and cross-examination of the witnesses. If you believe that part of a witness's testimony is false, you may choose to distrust other parts also, but you are not required to do so. Inconsistencies and contradictions within a witness's testimony or between witnesses do not necessarily mean that you should disbelieve the witness. It is possible for honest people to witness the same event and see or hear things differently. You should evaluate inconsistencies and contradictions and determine whether they are important or unimportant. You need not believe any witness even though the testimony is uncontradicted. Nor are you required to accept testimony as true because some or even all of the witnesses agree with each other. You may find the testimony of one witness or of a few witnesses more persuasive than the testimony of a larger number. These principles apply to all witnesses, whether they are ordinary citizens, police officers, experts, or otherwise. In short, you should consider the testimony of each witness and give it the weight you think it deserves. The weight to be given to the evidence should be determined by the quality of the evidence, not the quantity. It is not the number of witnesses or the quantity of the evidence, but the quality of the evidence that is important. The judge decides what is admissible. Testimony, writing, objects, and other things presented during the trial are evidence only if the judge accepts them as evidence. Throughout the trial, I may rule on whether certain evidence was admissible or not admissible. These are legal decisions which do not concern you, because only the judge is permitted to decide legal questions. I may make 3 types of legal decisions with regard to the evidence. First, I may stop some information from being presented at all. You are not to imagine what that information might have been had I allowed it to be presented. Second, I may rule that some information was not admissible after it was presented to you. You are to ignore this information and not use it as evidence. Finally, I may allow some information to be entered as evidence after hearing objections by one of the lawyers. You are not to give such evidence any special importance as a result of my ruling. It is not my duty, and I do not try to determine whether the evidence is important when I make my rulings. The burden of proof and reasonable doubt. Now, I've addressed what you should not consider and what you should consider in reaching a verdict. I'm now going to discuss with you how convinced one way or the other you must be, and this is referred to as the burden of proof. Under our constitutions, all defendants in criminal cases are presumed to be innocent until proven guilty beyond a reasonable doubt. The burden of proving guilt is entirely on the state. The defendant does not have to prove his innocence. As I told you earlier, the defendant enters the courtroom as an innocent person, and you must consider him to be an innocent person until the state convinces you, beyond a reasonable doubt, that he is guilty of every element of the alleged offense. If after all of the evidence and arguments you have a reasonable doubt as to the defendant having committed any one or more elements of the offense, then you must find him not guilty. Now finally, ladies and gentlemen, a reasonable doubt is what the words would ordinarily imply. The use of the word reasonable means simply that the doubt must be reasonable rather than unreasonable. It must be a doubt based upon reason. It is not a frivolous or fanciful doubt, nor is it one that can easily be explained away. Rather, it is such a doubt based on reason as remains after consideration of all of the evidence that the state has offered against it. The test you must use is this. If you have a reasonable doubt as to whether the state has proven any one or more elements of the crime charged, you must find the defendant not guilty. However, if you find the state has proven all of the elements of the charged offense beyond a reasonable doubt, you should find the defendant guilty. With respect to the final instructions regarding the offenses, I will wait until the end of the trial and after closing arguments and discuss it with you at that time. So as I said, I will give you another set of instructions after closing arguments at the end of this case. Evidence and abuse of corpse?
Yes.
And do you understand that it would be the state's obligation to prove each and every element of those offenses beyond a reasonable doubt before the jury could find you guilty? Do you understand that?
Yes.
And that by agreeing to allow them to acknowledge this in opening statements, the jurors can find you guilty of those 2 offenses relying
Yes.
on that information. Do you understand that?
Yes.
Okay, and that is what you wish to do?
Yes, ma'am.
Okay, do you have any further question about that?
No, I do not.
All right. Anything further that the state requests?
Nothing that's further than state request. We assume that the court would take that into account and make a decision whether or not he's making a knowing, intelligent, and voluntary waiver of essentially proving his facts and proceeding this way, which I'm sure the court will do.
Okay. So anything you want to add, Attorney Smith?
Not on that issue.
Okay. So, Mr. Montgomery, having heard from you that you've discussed this with your lawyers, that you've reviewed the opening statements, the draft of the opening statement, that you acknowledge, that you understand that the burden of proof is on the state to prove each of those offenses beyond a reasonable doubt, and that understanding that it is your desire for them to proceed with that strategy. The court does find that this is a knowing, intelligent, and voluntary waiver of your rights, and will allow them to proceed on that basis, okay?
Oh, yep.
Okay. While I have you, today you did refuse transport, so I want to talk to you about tomorrow. As we discussed with you this morning, you can't change your mind midway through the day, but you can inform the court if you wish to come tomorrow. And what I would like to do, and each day thereafter. So you can come, and we will send a transport for you. That is your absolute right. But as I explained to you this morning, it's also your right to waive your presence and for us to proceed in your absence. So what I'm going to do is I'm going to instruct the Sheriff's Office and the Department of Corrections that someone will ask you tomorrow morning, do you wish to come to court today? We will have transport available to you if you want to come, but I am not inclined to send a car up there to pick you up only to have you refuse. So do you understand that?
Yes, ma'am.
Okay, do you have any concern about that procedure?
No, I do not.
Okay, so it is our intention to have someone ask you tomorrow morning whether or not you wish to come, and whenever they come to ask you that question, they're going to need an answer from you so that we have sufficient time to make sure that we get you down here in order for us to start the trial in a timely manner. Do you understand that?
Yes, ma'am.
Okay. And I believe your counsel will be speaking to you later, at some point later today?
Not today.
Oh, not
We
today.
can't.
Okay.
24-hour notice.
Okay. So that's going to be the procedure for tomorrow morning and each day thereafter of this trial, unless and until the court makes a different order on that. Do you understand that?
Yes, ma'am.
Okay. Is there anything further from the state while Mr. Montgomery is present?
No, Your Honor.
Okay.
Thank you.
Anything further from the defense?
No, Your Honor.
All right. Mr. Montgomery, you're free to go now. I appreciate that that you are speaking with us when we need to speak with you, because we are keeping the jurors waiting when we do this.
Okay.
All right.
Thank you.
All right. You're all set.
One feels a little foolish about talking to a robot, but when I finally got Sam's struggle gear, as he is called, to settle down, I learned that he was in town for just a day selling coats for the company he represents. Presently, there are about 25 robots like him making promotional appearances around the country, and they can be programmed to do just about anything. I understand